All right, well, let's get started. Thank you all for joining us today. I'm NYAW Cabula of Debevoise and Plimpton, and today's panel will be arbitrating disputes with international organizations, Curio or Imbroglio. I'd like to first just thank NYAC and the organizing committee for 2022 New York Arbitration Week. I'd also like to thank my friends at ASIL for helping me organize this event, and ASIL is the sponsor of this panel. I'd like to thank my colleagues Lisa and Federico Winter at Debevoise for helping organize the panel. And also, last but not least, I'd like to give a very special thank you to Eversheds and particularly Uliana for hosting us and for providing for the CLE credit. For those joining on Zoom, the CLE codes will be posted in the chat every 20 minutes, and then a CLE form will be sent by email after the panel. So our topic is international disputes in which international organizations are parties, and we're going to try to bring some clarity to this somewhat mystical subject for a lot of people. So, you know, we're all aware that international organizations enjoy privileges and immunities and generally don't submit to domestic jurisdiction. And international law and institutions do not provide any infrastructure for settling disputes involving international organizations. Nevertheless, since at least 2002, the ILC has recognized a widely perceived need for a means of settling disputes involving international organizations. And just this year, the ILC added to its program of work, settlement of international disputes to which international organizations are parties. Several international organizations, including the UN, have developed a practice of arbitrating commercial disputes with contractors. For example, the UN, which engages in some $3 billion of procurement yearly, has provision for UNCITRAL arbitration in its procurement rules. So in today's discussion, we'll explore that practice and explore the ways in which it may or may not provide a model for arbitrating other types of disputes involving international organizations, including with other types of private parties, between international organizations, or between international organizations and states. It's, I think, a very fascinating and particularly current topic, given the ILC's current program of work. And I have to say, I don't think I could ask for a more distinguished panel to be discussing it with me today. All three of our panelists are incredibly accomplished, and I'll keep the introductions brief, but I could probably just spend the hour discussing their accomplishments. But I'll introduce them in the order they'll be speaking today. So first, here with me in person, we have Ms. Alexandra von Willison, a senior legal officer at the United Nations Office of Legal Affairs. Ms. von Willison leads the Arbitration and Claims Practice Group. So if we're asking, you know, who's in charge, which is the theme of New York Arbitration Week this year, well, Ms. von Willison and her colleagues are in charge of arbitrations involving the United Nations. She has incredibly broad experience in disputes involving the United Nations, having appeared as counsel in some 30 proceedings. And prior to joining the UN, she was in private practice in Zurich and in New York. Next, we have with us, joining virtually, Ms. Ashwita Ambas. She is legal counsel at the PCA, and acts as registrar and tribunal secretary in international arbitrations, including in cases involving international organizations. From 2018 to 2020, she was the co-registrar of the Mauritius International Arbitration Center. And prior to that, she was at a Magic Circle firm in London, and she's currently a JSD candidate at Yale. And last but not least, we have Dr. Kirsten Schmalenbach, professor of international and European law, European Union law at the Paris Lodron University, Salzburg. She was previously a law professor at Karl Franzen's University Graz and at the University of Beirut. She's led research projects on international rule of law and United Nations tort law. Her publications are too numerous to list, but they include pieces on responsibility and liability of international organizations. She's also acted as counsel in proceedings at the PCA involving international organizations. So now that we have the introductions out of the way, let's get into the discussion without further ado. So I'd like to start by giving the floor to Ms. Von Willison, who's going to introduce the subject of international organization immunity, which is central to any discussion about resolving disputes to which international organizations are party. And we'll go into the UN practice of arbitrating disputes with contractors and give some insight into who's in charge of handling those disputes for the UN.
Thank you very much, Navi, for the kind introduction. So I don't have to say anything about myself, other than perhaps just to mention, I stumbled onto arbitration a little bit accidentally, and I started really loving it over the past 10 or 12 years, or even longer. I'm a UN all-arounder. I've served in peacekeeping operations on 2 different ones, one in Haiti and one in Côte d'Ivoire. So I thought maybe best I start with the topic, who is in charge of handling UN UN arbitrations. And it's kind of, let's put it this way. I would like to maybe clarify that I can speak about the use of arbitrations as far as the UN and its funds and programs are concerned, not necessarily about the specialized agencies and related agencies. The UN funds and programs are integral part of the United Nations. They're subsidiary bodies that are created by the General Assembly. So in a nutshell, arbitrating disputes with individual contractors, commercial contractors, consultants, and other third parties, and representing the organization in settlement and arbitrations is one of the core functions of the Office of Legal Affairs, according to the Secretary General's bulletin. And I'm calling the Office of Legal Affairs OLA going forward, just to be simple, because it's not really about me and it's my colleagues. I mean, I have like at least 4 or 5 colleagues who are working. We are a team dealing with these arbitrations. And but it's basically Office of Legal Affairs that has the core function of handling these arbitrations. We handle them in most cases directly. Sometimes we support funds and programs in doing so. And when they do handle them, they sort of do it together with our support. What I think is maybe important to kind of draw back about who is in charge of UN arbitrations is that it's also kind of derives from the administration of the privileges and immunities that the Secretary General of the United Nations has delegated exclusively to the Legal Counsel, who is our boss. I mean, he's the head of Office of Legal Affairs, the Under Secretary General of Legal Affairs. So this is kind of the reason why arbitrations involving the UN are handled by us. And we very often also, let's say, often we are assisted by outside counsel. Now, what I think maybe would be worth mentioning is, at this stage, maybe a little bit further down, is that the role in supporting OLA's role in supporting the organization in these arbitrations is also kind of to take a balanced and principled approach. We are not litigious. We want to be balanced and principled whilst effectively, of course, defending the organization's interests. Our preferred, this goes away from arbitration, but our preferred outcome is always to settle the disputes amicably, if at all possible. If it escalates to arbitration, then we'll ensure a principled approach. So it's not like all gloves are off. We have somehow, we would like to, there's certain fairness and principle that we maintain while we are conducting arbitrations. So maybe that leads us into the topic of privileges and immunities, and I'm sure most of you, I don't have to kind of say much about it. It's kind of the underlying building block of the privileges and immunities is the UN Charter, which in Article 105 says that the organization shall enjoy such privileges and immunities as necessary for the fulfillment of its purposes. And then the basic provision of this principle has been expressed in the Convention on the Privileges and Immunities of the United Nations that was adopted shortly after its establishment of the United Nations in 1946. So they're like, importantly, the Convention accords the United Nations juridical personality, including to institute legal proceedings. And then also, as Navi has already mentioned, as everybody knows, it provides also the basis of the UN's immunity from all forms of legal process. So the immunity from legal process before national courts, accorded to the UN as an essential element of its ability to function within member states, places also at the same time an obligation on the United Nations to ensure that disputes that inevitably arise in the course of its functioning have a means of being settled. And this is also reflected, as you all know, in the General Convention in Section 29, and which articulates the obligation of the United Nations to make a provision for appropriate modes of settlement of disputes arising out of contracts and other disputes of a private law character to which they are party. So this brings me now to the part of speaking about the UN's practice of arbitrating disputes with commercial and individual contractors. So notably, Section 29 does not specify what constitutes a dispute arising out of a contract, nor what an appropriate mode of settlement might be. So it leaving the matter open to the United Nations to determine. And that also brings me back to your comment when you say the infrastructure is kind of hasn't been set out in international law, although that's just the basic let's maybe say that's the basic infrastructure. So what disputes arising out of contracts are, yes, these are usually contracts between the UN and commercial vendors. And then this has been like about 20 years after the 1976 UNCITRAL arbitration rules have been adopted by the General Assembly. The Secretary General then reported to the General Assembly that the provision or the long-standing practice of the United Nations was to make provision in its commercial contracts for recourse to ad hoc arbitration in accordance with the UNCITRAL arbitration rules. So that was reported 1995. There was apparently already a long-standing practice. So, and it's kind of interesting to look up this report because this report refers to, in order to implement to Section 29 of the Convention on Privileges and Immunities, it has been this practice that in the commercial agreements recourse for arbitration in the event a dispute that cannot be settled by direct negotiation. And also it reports that this practice has been followed by the UN subsidiary bodies, such as the UNDP or UNICEF. Also, this report reports that previously, before there were the UNCITRAL arbitration rules, there was those agreements, those commercial agreements invoked arbitration under different rules. For instance, the AAA rules, the AAA arbitration rules, and then also the ICC rules were mentioned. But this report also states the overwhelming majority of commercial agreements that have been entered into by the United Nations have been performed without the occurrence of any serious difficulty, and when problems have arisen, they have been resolved through direct negotiation in most instances. So that is sort of explains very much, and how can I say, the general policy that the UN has is to amicably settle its disputes, if at all possible. Flowing from this, ad hoc arbitration under UNCITRAL arbitration rules has also become the accepted form of settlement mechanism for disputes arising from contracts with individuals employed on special service agreements, consultants, individual contractors, and UN volunteers, as per their terms of their contracts with the UN. These individuals, which are also referred to non-staff personnel, are intended to be engaged on short-term basis for the provision of specific services for projects of limited duration. Currently, OLA, the United Nations OLA, is working on a simplified dispute settlement procedure for consultants and individual contractors to facilitate the dispute settlement by making the process less time-consuming and more cost-effective. So it is envisaged that the simplified dispute settlement procedure will include a phase comprising a strengthened informal amicable settlement dispute resolution, so strengthened, and if that fails, procedures for streamlined and simplified expedited arbitration to be adjudicated by a sole arbitrator based on the recently adopted UNCITRAL expedited arbitration rules last year. That was in September 21. And this is also in keeping with OLA's role to take a balanced and principled approach to arbitration insofar non-staff personnel are concerned, which do not have the equal bargaining power. So another way, and that's just a side remark, expedited arbitrations might be used in the future is for settlement of disputes between the United Nations and commercial vendors arising from the minimis contracts. So maybe to round up my remarks, I would like to also explain a little bit some of the distinguishing features of international commercial arbitrations involving the United Nations. As a result of its privileges and immunities, the UN does not agree to an applicable law, including substantive and procedural laws. It is a standard in UN contracts that there is no governing law provision. Instead, the arbitration clause included in the current general conditions of contract provides that the decisions of the arbitral tribunal shall be based on general principles of international commercial law. And then depending on the issue, an arbitral tribunal may apply general principles of international commercial, such as those reflected in the UNIDROIT principles. Also, as a result of the privileges and immunities of the United Nations, it has been the UN's position not to agree to a place or seat of arbitration, which would subject the arbitration to oversight of national courts and the application of local procedural laws. The UN commonly agrees to delocalized arbitration and commonly agrees to a place of hearing. Also, what is important, arbitral awards are considered by the United Nations in principle final. To date, only one award has been subject to a still ongoing annulment procedure, which was initiated by the opposing party. To date, the United Nations has complied with all arbitral awards. And conversely, when the United Nations has, when an opposing party was unwilling to comply with an arbitral award, the UN has amicably settled the resulting dispute by negotiation again and avoided any execution proceedings, which would require a waiver of its privileges and immunities. Also, what is kind of important is the United Nations is almost always the respondent. So now maybe just a little bit of information in terms of also a reflection on the United Nations attitude towards arbitration, as I already expressed. Whether it's a dispute with a commercial vendor or an individual, arbitration is really only the last resort when all reasonable efforts to settle have failed. Primary aim is amicable settlement. This policy has been by and large achieved by United Nations in the first 40 years of its life. There has been very, very few arbitration involving the UN before the 1990s. For example, there appear to have been a couple of arbitrations involving the United Nations Relief and Work Agency for the Palestinian refugees in the Near East in the late 50s and early 60s. And there was one arbitration involving the UN mission in the late 60s, and a couple of arbitrations, one arising from a bidding challenge and another from a lease during the 80s. Then in the mid-90s, with the rise of the UN peacekeeping operations, there's been a sudden upward trend. Over the past 27 years, there were close to 40 arbitrations were initiated by commercial vendors in which OLA has acted as the counsel, of which approximately about 30% involving UN funds and programs. The majority of these arbitrations arose from complex multi-million-dollar contractual arrangements between the UN and suppliers providing logistic support to peacekeeping operations, including the provision of fuel, food rations, catering services, transport services by air, land, sea, charter, air charter, and construction projects. There is also an upward trend in the number of arbitrations handled by OLA in-house without help of outside counsel, with close to 20 such cases since 2015. OLA handles an arbitration in-house each time when the client office does not have funding for outside counsel, which typically, but not exclusively, happens in disputes involving non-staff personnel. I hope I have not overshot my 10 minutes.
No, no worries.
Not really. Okay.
Thank you so much for those that preview into the UN practice, which is very interesting, and I think that kind of sets us up for our next panelist, who is Ms. Ambast at the PCA. So the PCA has become really one of the signature forums for arbitrating disputes involving international organizations. And so as a tribunal secretary and registrar at the PCA, Ashwita is one of the people in charge of administering disputes involving international organizations. So I'd like to now give the floor to Ashwita to tell us a little bit about those proceedings. What do they look like procedurally, and what are some issues unique to them?
Thank you very much, and good afternoon to everybody who's attending in person and virtually. I want to start by thanking the organizers, ACIL, NYAW, New York Arbitration Week, Evershed's Arbitration Place, and of course, NYAW, who is kind enough to put together such a wonderful panel and set up an interesting discussion that you've aptly called mystical, because it's a subject that we don't really talk about very much, but is nevertheless quite important. Thank you also for accommodating me remotely. I would have really loved to be there in person in New York, but I think, alas, have to settle to be present via Zoom. I'm going to speak for the next 10 or so minutes, as Nawi said, about the PCA's experience in administering disputes involving international organizations. The PCA has administered nearly, I would say around 50 such cases. So we do have quite a wealth of experience in an area that's relatively niche. By way of background, the PCA is itself an international organization. It was established in 1899 by the Convention for the Peaceful Settlement of International Disputes. And the objective of the PCA at its establishment was to be accessible at all times to resolve international disputes, which today includes within its scope disputes concerning international organizations. The PCA currently has 122 contracting parties. So I do think it's quite interesting for me to be on this panel and discussing this subject, because on the one hand, it is the PCA's objective to provide services in cases that could involve international organizations. But on the other hand, the PCA is itself an international organization, and therefore, in some senses, a potential user or a stakeholder in the discussions regarding whatever mechanism may exist for the resolution of disputes involving international organizations. So with that introduction, let me just launch into 4 points or 4 general characteristics that I really wanted to focus on that are common to the disputes that we administer involving international organizations. I listened with a lot of interest to what Alexandra had to say, and it's interesting to note that a lot of the characteristics that we observed across the disputes that we administer that involve a variety of international organizations are quite common in their procedural considerations to what Alexandra talked about. So there'll be quite a lot of similarities in the points being made with, of course, a few differences here and there. So I think the first point that I'd like to start by making is that the approach of international organizations to arbitrations that we tend to see is standardized. And what I mean by saying that the approach is standardized is that the agreements are typically enshrined in general terms and conditions, standard contracts that are prepared by the international organization. Sometimes we see instruments or agreements in headquarters agreements of organizations. And there isn't really in these different instruments a huge variation in the kind of rules that we see or procedural frameworks that are applied for the arbitration. So in our experience, of course, we see cases that use the PCA's rules. We have 2 sets of rules that were developed in 1996 that were intended to be for disputes between private parties and states, private parties and international organizations, and states and international organizations. And these were then consolidated in 2012 in the PCA arbitration rules. So we see these rules being used quite a lot. And it's natural that we would come to administer those cases. But as Alexandra mentioned, we also see the UNCITRAL rules in their 1976 form and in their amended versions, so in 2010, 2013, etc., being used in these sorts of cases as well. And I would venture to speculate that the reason why such a standardized approach may be used, or tried and tested rules are incorporated in these contracts is because international organizations, much like states, tend to have quite a wide net that's cast of their activities. And they may want to mitigate risks that arise from the day-to-day contracting in the same way that we see states also trying to do. So it's not surprising that they wouldn't want to be subject to a wide range of procedures in different cases that aren't necessarily familiar to them, or for which there isn't really a big repository of precedent. So of course, yeah, I'd be interested in hearing various panelists' view on this, but yeah, it was a thought that came to me while we were going through the different cases that we had. Second, and this is also quite in line with what Alexandra said, international organizations in the cases that the PCA administers are most commonly the respondents. And the reason for this might be that, of course, international organizations may have greater leverage with respect to, or in the particular relationship with the counterparties that they arbitrate with. International organizations have substantial activities, and they could end up in situations or be in a position where they withhold payment, or they can withhold future employment, or essentially in situations that could be subject to arbitration in the future. And so those are the kind of things that we see coming up in these disputes, or being the subject matter essentially of these disputes. So it's why we see arbitrations with international organizations usually having the international organization as the respondent. As a third point, I think there are a host of concerns about applicable or the application of national laws and standards. And I know Alexandra touched upon this a little bit. But as I think even now we said at the outset of this discussion, as a general matter, the reason why arbitration is so favored by international organizations as against national courts is because international organizations are reluctant to submit themselves to court and therefore seem as though they're waiving their immunity from judicial process. And so arbitration is an attractive default option and take sort of these disputes out of the national courts. Unless, of course, you have organizations that are able to set up their own specialized tribunals that can resolve disputes. So one example of this is, of course, the UN appeals tribunals. There are several examples of this nature. On a more substantive level, I have also observed a predisposition of international organizations to agree to use transnational standards as the substantive applicable law rather than resort to national legal principles. I think Alexandra already talked about general principles of commercial law and the NYAW principles. I've certainly seen those used in a variety of arbitrations, but we've also seen the CISG principles developed by the ILO Administrative Tribunal, particularly in the context of certain employment disputes, and also just general principles of international law. Like these tend to show up very often as the applicable law in these cases. I've also seen, similar to what Alexandra said, that international organizations have requested immunity from enforcement in certain cases to be inserted in the terms of appointment. So they would like something explicitly set out that their agreement to go to arbitration doesn't mean constitute a waiver of their immunity from enforcement. And at the same time, we've also observed that most international organizations highlight that they would be willing to pay an adverse award. So there shouldn't actually be a need for this enforcement action that happens later if there is an adverse award, because the organization would be willing to pay and comply with that arbitral process, which of course is very much in line with Alexandra's observations about how arbitrations tend to be conducted by international organizations, that it's a balanced and a principled approach, and the intention is really to comply with the process. But I do think it's quite interesting that this is a position that's taken, because of course there might be a situation where the organization wins and, for example, is awarded costs, but the position that they take might mean that they're willing to forego the possibility of enforcing the arbitration award and obtaining this favorable award of costs because they don't want to be seen as having waived their immunity before national courts. So I do think that there are various perspectives, I think, to this position that's taken. On the more procedural side, as Alexandra said, international organizations have a very particular view on the seat of arbitration. In some cases, I've seen international organizations adding express provisions in terms of appointment where they agree to there being a seat of arbitration, but it's expressly set out that the existence of the seat doesn't constitute a waiver of the privileges and immunities of the international organization. So there's sort of a little different, slightly different approach to what Alexandra said, where the seat exists, but there are certain caveats that are added to what that might mean for the arbitration or for the international organization. In other cases, as Alexandra observed, they favored having no seat of arbitration, which of course is very unique compared to a traditional or standard commercial arbitration, where having a seat is a very basic requirement for the arbitration to proceed. I think this is also quite interesting because it's it also suggests that international organizations may be willing to forego the protection that they may get from a seat. Suppose they're in a position where there is an award that's unconscionable and they would like to challenge it. If there wasn't a seat, then they're willing to forego the possibility of challenging that in order to preserve their privileges and immunities, which is another interesting aspect of the position that's been taken. More generally, I think these various considerations in relation to national law may also be why international organizations may favor other international organizations, such as the PCA, being the arbitration providers, or preferring to apply rules that have either been prepared by international organizations, such as the PCA rules, or that have been developed in a multilateral context, such as the UNCITRAL rules. So that's another interesting aspect of the exceptionalism from the application of national law standards. As a fourth and a final point, I think the majority of disputes that we've seen involving international organizations have been of a relatively modest size. That being said, I do think that these ultimately they are contentious cases, they have difficult issues, and they do need to be briefed and resolved. And so my observation would again be in line with what's been discussed previously, that to balance these various considerations, there has been a tendency to use expedited procedures to balance the costs of the arbitration while ensuring that the relevant procedures do run their course and that an award can be rendered. For example, in several cases, the PCA Secretary General has been approached to appoint arbitrators or to constitute the tribunal. And in doing so, has been asked to bear in mind cost sensitivities. And so we've been expressly requested in some cases to appoint arbitrators who are willing to act pro bono or at reduced rates. And happily, this isn't really a tough task because disputes involving international organizations are seen as prestigious and interesting disputes. And there are many, many arbitration practitioners who are willing to do this at a reduced rate or at reasonable costs. But it is a factor that we've seen is quite important even in our appointment practices. I think the point that Alexandra made about sole arbitrators being used is also very interesting because I think more than half the cases that we've seen that involve international organizations haven't been resolved by panels, but have been resolved by sole arbitrators. And what's interesting is that we've also seen that the processes that may be involved in appointing arbitrators may be in some cases abbreviated when international organizations are involved. So for instance, the appointment of a sole arbitrator under the UNCITRAL and the PCA rules typically involves a list procedure. So, the appointing authority or the PCA Secretary General would have to come up with a list of candidates, ensure that they're available, circulate it to the parties who would make comments and then return it. And then the appointment is made on that basis. But in cases, these modest sized cases, we have seen parties dispensing with that procedure and just asking for a direct appointment to be made because it's cheaper and faster. So that's another manifestation of these expedited procedures. Other observations in this regard are that document production, discovery, often done away with in cases involving international organizations. It might be because some of these disputes, as Alexandra had also alluded to, maybe, contract or employment-related disputes where there isn't really very much discovery that can potentially exist. And this also lends itself to the case sometimes being done on the papers, so there aren't hearings or hearings are done away with. I've also seen innovative uses of video and telephone conferencing in order to reduce costs. In fact, the very first Zoom hearing that I had was in a pre-pandemic world in a case involving an international organization. So I should say that there's also a lot of innovation that comes out of the need to keep time and costs under control in these cases. So I think it's a more general observation on procedure. I think there is room to develop, I think, expedited rules or use the expedited rules, such as the ones that UNCITRAL has recently developed in these cases. But so far, our experience has been that the UNCITRAL rules themselves and the PCA rules have been flexible enough to accommodate a lot of these innovations and introduce them into procedures that involve international organizations. So I think that's my time. So I'm going to close, but I do look forward to the panel discussion and any questions that may arise. Thank you.
Thank you so much, Ashrita, for kind of giving us a summary of what you've seen in these types of disputes at the PCA. And your comments really resonate with Alexandra's comments. And so I'll just kind of use your remarks to go back to Alexandra briefly. And so you've given us kind of overview of some of the key institutional preferences that drive some of the choices that the UN makes in arbitrations. And you referred to, an interest in expedited proceedings and using sole arbitrators. And Ashwita has mentioned a few others that she's seen in proceedings involving international organizations, including a preference for no discovery and perhaps no hearing in addition to those. And so I wonder if you could give us any insight into the kind of institutional preferences that drive those preferences, particularly for expedited proceedings and sole arbitrator, no discoveries, very streamlined.
Mm-hmm. Thanks for the question, and thank you, Ashwita, for your good expose. And I would also like to mention that the United Nations works together with the PCA in many of the arbitrations. So the PCA is really quite instrumental in supporting these arbitral proceedings. And what you mentioned, in response to your question, certainly these features that Ashwita just mentioned, like virtual hearing, doing away with document disclosure, are things that we would try to agree with the other party if it comes to a case with a non-staff personnel, for instance, just because it doesn't make any sense. It's too expensive and it simplifies the process. We would not necessarily, we have had a lot of it, we have quite some in respect to regular arbitrations, I'm calling them regular, like with commercial entities. We also have a slight preference of doing away with document disclosure because it has just been but more often than not, too expensive for the benefit that it ultimately produced. So we're trying to accomplish that, but very often, of course, this depends on the other side, on the opposing party, whether you can reach this type of agreement on document disclosure, doing it away. Also, we have put quite some thought into all these issues when we are drafting a revised dispute resolution clause for the general conditions of contract, which is not yet complete, but will be complete rather soon. And we're taking account of these, of this. So thanks for mentioning this, Ashwita. Certainly, we are always keeping costs, of course, in mind. Costs also for, not only for because we are spending public funds.
Right.
Yeah.
Thank you for that insight. And so one thing, Alexandra, you just made a distinction between commercial disputes and disputes with other kinds of private parties. So I'd like to just go back to Ashwita really quickly. And Ashwita, is there anything that you've observed, any kind of distinctions that you've observed in the procedure involving kind of commercial parties versus natural persons?
Yes, I would say that there are some differences. I'd say that a lot of the concerns about costs become much more heightened when it's a person versus a corporate entity as the claimant, because of course, under the UNCITRAL rules framework, it's for the parties to put up advances on costs. And when it's a person, it's really them putting up the amount. And so it really does heighten some of those concerns. I think confidentiality also becomes more important. I think particularly in the context of, for example, contract-based or employment-type disputes, it's typically like the documents concerned are really, very personal documents. And I think that, yeah, in those cases, they're almost always completely confidential and subject to, of course, any reporting obligation that the international organization may have to their member states or whatever else. But apart from that, they're all completely confidential. So I think confidentiality also becomes more important. But I think what's interesting, and this is an anecdote from my experience administering one of these cases, is that you would think that obviously some of these cases may be appropriate to not have a hearing and just do it on the papers for reasons of cost. But I've had two cases which have had individual claimants as individuals as claimants where they had requested a hearing. And I think part of it is because when it's an individual, they would like their day in court and perhaps want to go through this process of interacting with the tribunal and seeing their claims being adjudicated in a real sense. So yeah, it sort of drew my attention to, of course, you have time and cost savings on the one hand, but on the other hand, it's an interesting reminder that going through some of the more conventional motions of dispute resolution may also be relevant to some kinds of dispute procedures. And we were able to do it quite cost effectively because, you know, you have other means in place. But yeah, I do think that sometimes with individuals that might be an element that companies may be less interested in.
Yeah, thank you. And that's interesting. And you touched on something that we haven't touched on yet, which is the confidential nature of many of these proceedings. So it's interesting to see that you perceive the distinction between the interest in confidentiality in proceedings involving natural persons versus companies. Okay, so now let's turn to Dr. Schmalenbach, the non-IO representative on our panel. And she's going to explain, explain the ILC's program of work, what some of the outcomes of it might be, and talk about maybe some of the her observations about arbitration and disputes between non-commercial parties and international organizations. So Professor Schmalenbach, you have the floor.
Thank you, Navi, for inviting me to be part of that very impressive panel, whose topics are indeed highly relevant and quite often overlooked. So thank you for having me here, and a good afternoon to the audience and to my other panelists. The 2 points I will cover in the following 10 minutes are, first, the International Law Commission's work on the topic, quote, settlement of international disputes to which international organizations are party. And second, the possibility and challenges of using arbitration for disputes between states and international organizations. And without further ado, let's go straight to my first topic, the ILC. Back in 2016, the subject matter, IO, International Dispute Settlement, I use that short form, was put on the ILC's long-term work agenda. And it took the ILC 6 years to get around to actually working on the topic. That's not unusual for the ILC to take its time to start working on a topic, and admittedly 6 years is relatively quick. This speed admittedly took me by surprise, as the ILC has had in the past a rather rocky relationship with IO topics. And this is basically because some ILC members consider IO simply extensions of states rather than independent actors and subjects of general international law. As the case may be, this year in May 2022, the first phase of the work kicked off with the appointment of my colleague, Professor August Reinisch from Vienna, as the special rapporteur. Little of substance is known yet, as August Reinisch is in the process of sending questionnaires to states and international organizations, the content of which is not my story to tell. Anyway, this early in the process, the major aim of the ILC's questionnaire is to gain insights into practice. For our discussion today, the practice of international dispute settlement to which IOs are parties. The special rapporteur will be heavily dependent on these insights, as most dispute settlement proceedings are conducted behind closed doors. By way of example, ILC Special Rapporteur Michael Wood, who introduced the IO dispute settlement topic in 2016, could only identify in the public domain 4 cases of arbitral proceedings between an IO and a state. I personally couldn't find a single case of arbitral proceedings between 2 IOs, which does not mean that there are none, but it tells you something about public access to information. So naturally, the ILC's work on IO dispute settlement will go far beyond arbitration, as it also covers internal dispute settlement processes within an international organization, informal and formal processes, as well as judicial, quasi-judicial, and diplomatic means of dispute settlement. Indeed, the topic is extremely broad and thematically diverse. That makes the topic very difficult for the ILC, as it is not the task of the Commission to simply do a stock-taking exercise and report on how many dispute settlement options exist in practice, how often they are used, or whether the existing options satisfy the need of the parties. No, at the end of the day, the ILC's aim is to identify or to push for international rules, standards, and conclusions that have a general application. Regarding the IO dispute settlement topic, the question is then, which rules require identification? I'm not giving away any secrets when I say that it will probably not be procedural rules of arbitration. Back in 2016, Michael, excuse me for a second, do you hear the echo or am I the only one?
No, we're not getting the echo here. We can hear you clearly.
Okay, thank you, because for me it's quite irritating, but nevertheless, the most important thing is that you can hear me. So anyway, so in 2016, Michael Wood referred to the PCA optional rules as the reason why he saw little value in simply developing another set of model rules. If identifying rules of arbitration and procedures is not going to be the ultimate aim of the ILC project, then what is it? At the current stage, I can identify two topics that are especially suitable for generating articles or conclusions on IO dispute settlement. The first topic is the admissibility of claims brought by an IO against a state or vice versa. The second topic concerns the jurisdiction of the dispute settlement body regarding claims of private party against IOs. Both topics are to a certain extent interrelated. Let's have a quick look at the first issue, the admissibility of a claim, which concerns, for one, the ownership of the claim, and second, the necessity to exhaust local remedies. For example, it is very often a cause for dispute between IOs and states when states take measures against IO staff members, for example, by injuring, detaining, or prosecuting them, irrespective of immunity. This may trigger the functional protection of that person by the international organization. The question here is, are there any admissibility rules governing an IO's functional protection claim against the state? Rules, for example, regarding the quality of the employment relationship between the IO and the affected person, analogous to the nationality rule under diplomatic protection. So conversely, a state may have a diplomatic protection claim against an international organization because the IO has harmed one of the state's nationals. This triggers a set of interesting admissibility questions too. First, whether IOs are obliged under international law to allow states to exercise diplomatic protection on behalf of its national. That is by far not a given. Second, whether the claim is admissible if the protected national is at the same time a staff member of the IO or a locally recruited person. And third, whether the local remedy rules apply to this dispute, meaning that the claim is inadmissible if the harmed person has not exhausted the IO's internal administrative claims procedure. That brings me to another issue that may be addressed by the ILC: disputes between IOs and private parties. This issue concerns the jurisdiction of the dispute settlement body, including arbitral tribunals. Section 29, and we heard that already, of the UN Immunity Convention requires the UN to provide for alternative dispute settlement in cases of third-party claims of a private law character. This language is echoed in other documents, for example, in the headquarters agreement of the International Criminal Court, and in contrast, the headquarters agreement of Interpol foresees arbitration for disputes between Interpol and private parties without any reference to claims of a private law character. It seems reasonable for the ILC to address the question of whether a general rule exists that limits the jurisdiction of dispute settlement bodies to claims of a private law character, if either private parties are claimants or the state of nationality espouses their claims. Such a rule would exclude, for example, claims based on the violation of international law, such as human rights law, from arbitration, also claims based on the ILO's constitution. In this regard, an additional observation can be made. Originally, the ILC's work plan focused on disputes between international organizations and disputes between IOs and states. However, there is no doubt that disputes between IOs and private parties, be it individuals or corporations, are of much greater practical relevance. Some ILC members are aware of this fact and are pushing towards including these aspects into the work. However, the ILC is a subsidiary organ of the General Assembly. Therefore, the ILC might face some resistance from the UN if it wants to pursue private party dispute settlement forcefully. And at the end of the day, the UN is, and Alexandra will forgive me that I say that, the UN is not a neutral bystander in this matter. One needs only to recall the UN's reaction to the Haiti cholera claim, and I do not judge on that. It's only a very, very sensitive topic. Consequently, the ILC may run into a brick wall if it tries to take a too progressive attitude towards jurisdiction over all kinds of individual claims against IOs. Turning to my last topic, the possibilities and challenges to use arbitration to settle international disputes between IOs and states. As already mentioned, the number of actual arbitral tribunal proceedings to which IOs and states are opposing parties are limited, at least to my knowledge. Obviously, one main reason is the strong diplomatic ties between states and IOs, which often means dialogue is a tool of choice rather than arbitration. A motivating factor to find diplomatic solutions can be that neither parties wants to have an award that turns into evidence for a rule of general applications, for example, regarding limits of immunities. And then again, the fear of precedents can be a valid reason to return to arbitration too. This is because one of the proceedings advantages, and we talked already about that, is confidentiality. However, and that's my last point, arbitration is a two-edged sword. For international organizations, arbitration is always risky, as arbitral awards can have an impact on the organization's functionality. It's just not foreseeable whether a given arbitral tribunal will consider an organization's operability and effectiveness the linchpin of all its rights and duties. However, the risk of being contradicted in one's legal opinion is the risk of every judicial proceeding, and I personally see no reason why international organizations should be above this risk. And with that, I close and thank you very much for your attention.
just a moment. Okay. Yeah, so I was just going to follow up with a question about your comments about resolving disputes with private parties. And you kind of actually previewed or alluded to it in your comments about admissibility and diplomatic protection, but the concept of internal procedures within international organizations to resolve disputes, for example, with their employees, is that's common. We know that exists, and so there's a potential to resolve those types of disputes through arbitration as well. Or I guess my question is, do you think those procedures are adequate, or should we be thinking about arbitration as an alternative?
Thank you for that question. As usual, there are pros and cons to be considered when assessing internal mechanisms as a proper way to settle disputes between international organizations and private parties. These mechanisms, for example, are claims review board. The UN has them in their peacekeeping missions. And these internal mechanisms are part of the IAO's administrative body, and they fall by no means into the category of judicial or quasi-judicial dispute settlement. There are at best fora for negotiations between the aggrieved private party and the organization. I do not deny the usefulness of such mechanism. The problem, however, lies in the fact that there may be a considerable power imbalance between the private party as claimant and the organization as a respondent. Thus, these negotiations with the IAO's administration, these are the local remedies I spoke about, often end up with an offer that the private party has difficulties to refuse. Naturally, the IAO applies its own rules to this offer. However, given the power imbalance between the parties, negotiations may easily exhausted themselves in, and take it or leave it offers. And with regard to IAO's rejections to negotiate dispute settlement, if they consider the claim of a public international law character instead of a private law character, the IAO is frankly judge in its own course. So I do think arbitration is the better way to go in these cases.
Thank you, Professor Schmalenbach. I believe you wanted to make a comment, Ms. von Willison.
Thank you, Professor Schmalenbach, for this comment. Just one comment. The internal dispute settlement mechanisms that the UN has employed. I mean, I'm giving you one example. It has made progress, for instance, in respect to grievances. In 2010, a new two-tier administration of justice system was established with 2 independent tribunals. So that became much better than it was before, when it was sort of an internal review process and only like a last instance review by a tribunal. In terms of the claim settlement boards that you referred to, it is very true that probably in reality, okay, what I would like to say, in reality, it is, of course, open to any claimant, third-party claimant, to go further than the offer and go to arbitration. In reality, there have been only 2 arbitrations that have been initiated by third parties that arose from a peacekeeping context. So that kind of probably confirms your assessment. On the other hand, what I would like to add here, and that's probably not the answer, but these claims, they get reviewed by the claims review board. Then they go to the controller's office. The controller's office sends them to the Office of Legal Affairs, and it is being reviewed by the Office of Legal Affairs, as I said before, in a very equitable and balanced manner. So it's not like if we believe there is liability and there is an amount owed, this is going to be the recommendation. So that's maybe my response to what you just said.
Thank you. It's great to be able to get the competing perspectives on that and on a subject of such significance. We are over time, and I have been told to wrap up, or they're going to bring out the hook. So thank you so much, everybody, for joining us. I think this has been a remarkable discussion, and we really appreciate that you were able to join. Thank you so much for the panelists, to all of you for offering such insightful remarks. And thank you to New York Arbitration Week and Eversheds for hosting us. Take care, everyone.